Late start. Welcome to the Falls Township Board of Supervisors meeting for December 19th, 2017. We're going to begin with the Pledge of Allegiance, please.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, thank you. Mrs. Pullen?
Mr. Galloway?
Here.
Mr. Bransky?
Here.
Mr. Harvey?
Here.
Mr. Vince? Mr. Rocco?
Here. The records show Mr. Dents is battling some kind of bad stomach flu, so he is not able to be here, which is good because none of us want to get the stomach flu. So hope he feels better. Before we begin, I'm going to ask the solicitor, Mr. Clark, to give us a summary. Over the past few weeks, the township, the board has had several executive sessions, including one just before this meeting. Mr. Clark?
Thank you, Mr. Harvey. On December 7th, the board held an executive session to discuss personnel and litigation matters. On December 14th, the board held an executive session to discuss litigation, potential litigation, personnel, and collective bargaining agreements. And earlier this evening, the board held an executive session to discuss personnel and collective bargaining agreements.
Okay, thank you. All right, we're going to begin. Well, we have public comment sign-in sheet here, but nobody signed up, so we'll move on to item number 2. Okay. Agenda item 2 is Mazda Iron and Steel waiver of land development, 60 Solar Drive. Mr. Gray?
Yes, this property is zoned MPM. The applicant's proposed improvements consist of the construction of a tent, installation of various shredding equipment, and delineation of various stockpile areas for their finished and unfinished materials to support their operation.
Good evening. My name is Mike Peters. I'm here on behalf of TMM Holdings LLC. Mr. Gray's summary was accurate. This property is in the KIPC. It's located at 60 Solar Drive. There are no specific structural improvements proposed in connection with this project. The project involves the processing and sorting of metal, and it's light metal, so washers and dryers and things of that nature. The metal comes in, it is downsized to about 5 foot by 18-inch sections. It is then put into a sorting area. You'll note on the plan we have a larger dark square. That is a tent that is to be erected. The materials are stored and sorted under the tent. They are then taken off-site, not using trucks, but we're actually going to utilize the rail and the dock. There are going to be approximately 15 to 18 trucks that come in a day, 15 to 20 employees. We have 40 parking spaces, 22 are required, and we have reviewed the resolution that was provided to my office. The resolution is acceptable to my client, so the board is aware. There are 5 waivers that we're requesting. They're relatively typical waivers within the KIPC on a developed site of this nature. We're requesting a waiver that requires driveways be constructed with curbing, and that's section 19136D. Section 19137G, a waiver from the section that requires raised planting beds within off-street parking facilities. Section 19148, a waiver from the section that requires street trees be planted along street frontages, and a waiver from section 19162B, which is the section that requires curbs along existing street frontages. The street that this property is accessed off of is a private street, and our final waiver is from the requirement that we show existing features within 200 feet of the site, and we're certainly willing to provide any information that the township engineer requires. With that, I have Kristen Holmes, our engineer, here, who can answer any questions for you this evening.
Okay, thank you.
You're welcome.
All right, comments or questions from board members for Mr. Peters or Ms. Holmes? Mr. Galloway?
No questions.
Thank you.
No question.
I have none.
None? Mr. Sullivan, anything from you?
I have no comments at this time.
Okay, Mr. Clark, nothing?
Nothing.
Okay. Yeah, it's a very straightforward plan. It's very simple. Just so you, for clarification, I guess maybe from Ms. Holmes, just for people out there, you talk about erecting a tent, just so they know that it's not the one with like clowns and elephants and stuff.
It is not. It's much more boring than that. You want to explain it, Kristen? Or?
Sure. It is essentially a temporary structure that's going to be placed upon the existing pavement of the area. It will be supported and held down by actually containers along the sides of the tent. So there's no footings or foundations. It's going to be placed on the ground. It will be a large, just over 5,000 square foot tent, basically just a covered area for the operations to be done under.
Yeah, these are shipping containers you're talking about. They're
Yes,
on, right?
yes,
Like you see
along the sides of the tent.
Right, on cargo ships, okay. All right. Okay. Yeah, and everything, I said, the plan's pretty straightforward. Any public comment or question? See no hands. Okay, so this will be resolution 1730.
30.
Okay, is there a motion to grant resolution 17, or approval to resolution 1730, which is a waiver of land development for Mazza Iron and Steel?
So moved.
Second.
All in favor? Aye. Okay,
Thank you for your time.
Okay, next item on our agenda, item number 3, Marsville Commons LP remanded conditional use, West Trenton Avenue, Pine Grove Road. This relates to the redevelopment of the old Acme site, and the decision by the board many months ago to grant conditional use approval for the redevelopment of that site. There is a legal case into it, and the decision by Bucks County Court of Common Pleas Judge Gilman was to ask the township to essentially explain its point in granting that conditional use approval and allow for testimony to be heard at a board meeting so that could be entered into the record. And that's what we will do at this point. So we're going to have a hearing. At this point, the chair will look for a motion to open the hearing.
So moved.
Second.
Okay, all in favor? Aye.
Aye.
Mr. Clark?
Thank you, Mr. Harvey. The original hearing on this matter was held on May 15, 2017, and it was a conditional use application for the sale of fuels. The Board of Supervisors approved that conditional use application at that same meeting on May 5, 2017. The record from that hearing will be incorporated by reference into the record this evening. Subsequent to that decision, there was an appeal filed in the Bucks County Court of Common Pleas. By order dated October 24th of this year, Judge Gilman ordered this matter remanded to consider the applicant's compliance or lack thereof with the specific criteria of the Falls Township zoning ordinance. The order, I think it's safe to say, left both Ms. Gallagher and myself and the applicant's attorney and the appellant's attorney a little confused as to exactly what we were being asked to do. So 6 days later, a conference call was held with Judge Gilman, and Judge Gilman indicated that he had two main concerns. One, he wanted the township to essentially go through its files to determine if there was any legislative history regarding the zoning ordinance. And he wanted to determine what the basis was for the zoning officer, Mr. Bennett, for his preliminary opinion. This evening, we will be presenting an affidavit from the township manager who has searched the township records and has found no legislative history with regards to the zoning ordinance, and we will be admitting the minutes from the meeting where the zoning ordinance was adopted. In addition, we will call Mr. Bennett and have him testify as to the basis of his preliminary opinion. For the record, we would like to mark as T2 and T3 the proof of publication and the posting for this hearing this evening. We would like to mark as T4 the affidavit of Peter Gray, Township Manager, indicating that there are no records other than the December 16th, 2008 minutes. We would like to mark as T5 those minutes of December 16th, 2008. And we would like to now call Mr. Bennett to testify. And for the record, Mr. Bennett is the Township's Chief Code Enforcement and Zoning Officer.
Bennett?
Want to do this now, or
What are you doing?
notices to the neighbors?
Yeah, I just read his marked them.
What's that?
We just marked them.
No, that was the,
What?
that was the publication
I do.
in the newspaper.
Okay. And Mr. Harvey, before I begin with Mr. Bennett, just to clarify, we also will be marking the notices to all of the neighbors as required by our ordinance. Mr. Bennett, can you state your job title?
I'm the Chief Code Enforcement Officer and Zoning Officer for Falls Township,
And how long have you held that position?
10 years.
What are the daily responsibilities of that position?
Daily responsibilities are to make zoning determination as to what's permitted for uses and also setbacks, and to run the Code Enforcement Department.
And during the course of your employment with the township, have you become familiar with the township zoning ordinance?
Yes.
And in the course of your employment, have you become familiar with the various uses permitted throughout the township?
Yes.
I want to draw your attention to November of 2016. Do you recall receiving a letter from Attorney Thomas Hecker regarding the property that is at issue in this application?
Yes.
For the record, we'd like to admit as T6 the letter from Thomas Hecker to Mr. Bennett dated November 11, 2016. And Tom, if you can come over. Is this the letter that you received?
Yes.
You can bring that back with you. And while the letter speaks for itself, in that letter, did Mr. Hecker request that you issue a preliminary opinion regarding the subject property?
Yes, he did.
And did you issue that preliminary opinion?
Yes, I did.
And for the record, that preliminary opinion has previously been admitted as A2 in the prior hearing. Mr. Bennett, in issuing the opinion, did you take into consideration the various provisions of the township zoning ordinance?
Yes, I did.
Okay. In particular, which section of the code formed the basis of your opinion?
Section 209.5, which is definitions, and Section 209.23, which is highway commercial zoning district.
And in Section 209.5, did you specifically look at the definition of service station?
Yes, I did.
And do you have a copy of 209.5 in front of you at this moment, Mr. Bennett?
I have my book over there if you want me to get it.
Here, I have a copy. And could you read the definition of service station?
A service station, a lot or building providing for the sale of fuels, lubricants, automotive accessories, maintenance, and minor repairs of motor vehicles, but no body repairs or painting or storage of inoperable or wrecked vehicles are permitted.
And did you also, you indicated you looked at 209.23D?
Yes.
And that is the section that deals with conditional uses in the HC district, correct?
Correct.
So, Mr. Bennett, based on your 10 years of experiences as the Township's Chief Code Enforcement Officer and Zoning Officer, your review of the zoning code, your familiarity with the various uses throughout the Township, and the consultation with the Township solicitor, did you form an opinion as to whether the proposed use as described in the November 2016 letter was a service station or an automobile service station?
My opinion is it's not a service station.
And is that what your opinion was, what you put in your letter?
Yes.
Okay. I have no further questions for Mr. Bennett. Mr. Harvey, it would be appropriate now for either of the attorneys who are present on behalf of the applicant or on behalf of the appellant to ask Mr. Bennett any questions as they deem appropriate.
Okay. Is there anyone interested in doing so? Any of the attorneys for the applicant or for people of party status?
Francis Dillon here on behalf of the applicant. I have no questions, Mr. Bennett.
Okay. Thank you.
Joseph Caracap, I have some.
Okay, Mr. Caracappa, please come forward. Both microphones should be operable. So you're gonna need to be, yeah. Well, so they can hear you anyway, so yeah, you need to use the microphone.
Mr. Bennett, you said you've been the code enforcement and zoning officer in the township for 10 years?
Yes.
Mr. Bennett, do you know when Section 209-50 of the ordinance, which of course contains the additional standards for automobile service stations, including the 1,500-foot minimum distance between stations, was adopted by the Board of Supervisors?
No.
In the history section of the ordinance, it says, it indicates December 2, 1975. Does that sound right to you?
I don't have the book in front of me, so I don't know.
Right. If that's correct, and that's when the ordinance was adopted, the 1,500-foot minimum distance between stations has been an ordinance in the township for over 40 years. Would that be correct?
If it were a service station.
No, I'm asking you about the ordinance and how long it's been on the books in the township.
I don't have that in front of me, so I don't know.
To your knowledge, Mr. Bennett, has there ever been in the township a substantive challenge to Section 209-50's requirement of 1,500 feet between service stations?
No.
No, you don't know, or there has never been a substantive challenge?
There hasn't been one in my time that I'm aware of.
Are you aware of a challenge before you became the code enforcement officer?
No.
Okay. There's never been a challenge then to the validity of that ordinance as far as you know?
Not as far as I know.
No one has ever filed for a curative amendment involving Section 209-50, to your knowledge?
No, not as far as I know.
Okay. Mr. Hecker's November 11, 2016 request for a preliminary opinion was directed to you, was it not?
Yes, it was.
Okay. Do you know why it was directed to you, Mr. Bennett?
I would assume because I'm the zoning officer.
Okay. To your knowledge, was Mr. Hecker directed to send the request for a preliminary opinion to you?
Not to my knowledge.
Okay. Did you understand, Mr. Bennett, when Mr. Hecker, in requesting a preliminary opinion from you, the document you have in front of you, was challenging the validity of Section 209-50?
I believe he wanted clarification on the definition of a service station.
You believe that from what he put in the request, right? I mean, in the request, he told you what his opinion of that section was, correct?
I believe he wanted to know my opinion
Okay.
of what a service station was.
All right. So it wasn't your understanding that he was challenging the validity of this section of the ordinance, 209-50?
All I know is he wanted to know my opinion of the definition of a service station as it's written in the zoning book.
Right. And, but just to be clear then, there was no existing challenge to the validity of 209-50 and its 1,500-foot minimum requirement, either from Mr. Hecker or anybody else, at the time you got that letter request in November of 2016?
I don't know if it's proper for me to object. He's your witness, but.
I don't think so.
Mr.
You're a
Hecker-
party, you can object.
Mr. Hecker has the right under municipal planning code to do what he did. It's provided for by the planning code. He asked for the opinion, it was given and then properly published afterwards. The procedures will follow, motivation or what's happened prior, or I don't see where it makes any relevance in this.
We're not in a courtroom right at the moment, Mr. Dillon, and actually, it's an odd setup where I'm going to be making a ruling on a question being asked to my witness, but I think Mr. Caracappa should be given a little latitude to try to ask Mr. Bennett these questions, and if it starts to go, too far afield, then maybe we'll stop it. But I think he's trying to make a point, and hopefully we'll be able to move on from it if he's not able to make that point quickly.
Which I think I can do. I was just trying to get the record straight every time. The section of the municipality's planning code that Mr. Hecker requested a preliminary opinion under, it talked about challenges to the validity of an ordinance, did it not?
I believe it did.
Okay. And I'm just, all I'm trying to get clear for the record is that the ordinance that was challenged was not section 20950 and its 1,500-foot proximity regulation.
I didn't understand that.
Okay. After the Falls Township Zoning Board rendered its decision on January the 21st of 2015, denying a variance from that section of the ordinance, the proximity regulation, the Township Board of Supervisors attempted to amend section 20950, did it not?
I don't know.
You don't know. You don't know that it had its solicitor draft an ordinance reducing the minimum distance between service stations from 1,500 feet to 500 feet?
No, I didn't know that.
I have access to a letter Mr. Bennett, I have access to a letter from, it's dated February 4, 2015. It's from Michael P. Clark, the solicitor for the township, and it's directed to Jan Dickler of the Levittown Regional Library, which references a proposed an ordinance to be adopted by the Falls Township Supervisors at its public meeting on Tuesday, Feb. 17, 2015.
Okay.
Okay, but is this news to you that an ordinance was enacted to amend that section?
Yes, I didn't know they were amending that section.
Okay. So then obviously you don't know what happened to that vote the night that the ordinance came up for consideration in the Board of Supervisors. You don't know what happened.
No, I don't.
All right, that's all the questions I have. Thank you.
Okay, thank you. I think that's all the party status.
I believe so. I don't believe anyone else has requested party status.
Okay.
Mr. Harvey, so the record is clear. Mr. Caracappa is correct that in February of 2014, my office drafted an amendment to the zoning ordinance which would have eliminated the 1,500 feet restriction. It was advertised, but as all of you know, because all of you were here at that time, it was never adopted by the board. And I have no additional questions of Mr. Bennett.
Okay. All right. Thank you, Mr.
Could I have that document marked as Exhibit Shell 1 in the record?
Sure. Okay. All right, Mr. Bennett, thank you.
Okay.
So I believe it would be appropriate to ask Mr. Dillon or Mr. Caracappa if they have any brief remarks they'd like to make. And then if not, you can close the hearing, see if there's any public comment, and then the board will take a vote.
Okay. Mr. Dillon?
I assure you I'll keep them brief. I've reviewed the record, and this board at its last hearing found that the applicant had presented credible testimony and documentary evidence. It also found that the applicant has met its burden of proof that we have met the criteria of your ordinance, which mainly dealt with traffic, parking, lighting, loading, utilities. So we presented all that testimony. It's already before you. And you also found at that hearing, it also found in your findings of fact that the objectors did not present sufficient evidence to contradict the evidence which we had presented. I suggest again to you that we've met the requirements of the ordinance, that as you've already found, it was credible evidence, and that we've met our burden of proof, and we'd ask you to reaffirm your prior decision if that's the procedure that you're following this evening. But thank you.
Okay, thank you. Mr. Caracappa?
With all due respect to Mr. Clark, I'm not sure what there is for the board to vote on tonight. I didn't know that this had to do with a vote at all. I think Judge Gilman's order is very clear. The township supervisors were ordered to make a record on those specific items. I don't know what there is to be called for in terms of a vote.
Well, I believe, again, it's just a reaffirmation of a prior decision based on evidence that we're hearing now, which may or may not be new to us. I think maybe just an abundance of caution, Mr. Caracappa, that we're going to reaffirm that after all of this information has been heard publicly, that we're still of whatever, have the same opinion, or if people have changed their minds. Board members haven't talked, obviously, about it since we've started this. Mm-hmm. So we'll.
And again, Mr. Harvey, I agree with Mr. Dillon when he says if that's the procedure we're following this evening, and I understand Mr. Caracappa's comments. It is an abundance of caution. It is a bit of, we're in a little bit of uncharted waters. Judge Gilman wanted us to send it back to have the record supplemented, but we believe that under the circumstances, if what you've heard tonight, either in the form of testimony from Mr. Bennett or in argument from either of the attorneys, that if it would change the decision that the board reached in May of this year, then that should be the vote. If it doesn't change, we just think to make the record as clear as possible that you should just affirm your decision.
Okay.
So again, not sure if it's 100% necessary, but the one thing we really want to avoid is being back here again on this issue, and hopefully we'll be able to send this back up to Judge Gilman with sufficient information that he can make a determination.
Anything else, Mr. Caracappa?
No, I'm not going to argue the merits of the case. I mean, I filed a brief. Mm-hmm. I've challenged granted the conditional use. I don't think there's anything to be decided by the board tonight, but that's Mike's call, and very well. So thank you.
All right. Thank you. All right. So at this point, we'll entertain a motion. Oh,
just the original certificate of service. I provided a copy earlier.
Okay. Thank you. At this point, we'll close the hearing, and we'll open up for public comment on this issue following that. Is there a motion to close the hearing?
So moved.
Second.
All in favor?
Aye.
Okay. Is there any public comment? All right. See no hand. All right. So again, on the after hearing the evidence is presented, I guess the board is being asked at this point whether or not it reaffirms its prior decision granting conditional use to Marsville Commons LP at West Trenton Avenue and Pine Grove Road. Is there a motion to reaffirm or a motion to not reaffirm the prior decision?
Motion to reaffirm.
Seconded.
Okay, motion reaffirm made and seconded. All in favor? Aye.
Aye.
Okay. All right. Okay. Item 4 is public hearing for consideration of application for Superior Motor Services for standard tow truck wrecker service
I gave them to you, right?
for the 2018 calendar year.
I handed them to you when I handed at the same time I gave them to Mr. Dillon.
But we'll get them to you if you don't have them.
Yeah.
Okay, we'll give people a chance to sort of some people making their way in and out following the hearing. Just for the record, the item number 5 is no longer on our list. That particular company, tow truck company, withdrew their application to be on our 2018 list, and so there is no number 5. So we'll be skipping right to 6 after item 4. Okay, so as longtime viewers of our program will know, the township does operate a tow truck driver list, a wreckers list, essentially for cars that are involved in accidents or cars that become inoperable on township roads or on roads in the township that the township has supervision over. A wreckers list is kept so that a police officer who's encounters such a vehicle can call up to Doylestown, and they will use that list to call whatever towers on the list for that day, and then that tow truck driver comes out and provides the service they provide. The township doesn't have its own vehicles to do that kind of work, and so we do have a list of wreckers who do that. There is no monetary connection between the township and the wreckers. There's not a contract. We don't provide any payment to them, but we do require that they provide us various information regarding things like insurance, driver's background information. We require that their vehicles carry certain types of equipment and supplies to deal with different eventualities they run into, accidents or disabled vehicles, et cetera. And in November, basically in November of every year, companies interested in being on the wreckers list, towers list, have to provide that information to the township. It is reviewed by the police department as well as by council to make sure that essentially all the I's are dotted, T's are crossed. And occasionally there are issues with those applications that have to be dealt with and have to be dealt with in a hearing. So it's what we're going to be entering into now. So at this point, I'll make a motion to open the hearing with regards to Superior Motor Services.
So moved.
Second.
All in favor?
Aye.
Ms. Gallagher?
Thank you, Mr. Harvey. As you noted, this is a hearing pursuant to Section 206(5)(b)(2), the Township Code of Ordinances, which requires the board to hold a hearing to determine whether a particular license application should be revoked or denied. And I'm going to admit a copy of Chapter 206 as the Township's Exhibit 1. The township received an application from Superior Motor Service Incorporated on or about November 17th, 2019, which we'll admit as Township Exhibit 2. The application indicates that the lot to be used for the storage of vehicles is 218 Lincoln Highway, and that the applicant's primary place of business is 375 South Flowers Mill Road in Langhorne, Pennsylvania. That address is located in Middletown Township. And pursuant to Section 206(5)(b)(4), licensed wreckers in the township are required to utilize a lot within the boundaries of Falls Township to tow wrecked vehicles to. Upon review of the application, it became apparent that there may be an issue that required a hearing. So notice was sent to Mr. McCoy, who is the owner and operator of Superior Motor Services, on December 13th, 2017, notifying him of this hearing this evening, and that'll be admitted as Township Exhibit 3. There is a receipt for acknowledging receipt of that notice, which will admit as Township's Exhibit 4. And that's the background information, and with that, I would like to take some testimony from Jim Sullivan.
Yes.
Mr. Sullivan, could you tell us your role with the township?
I'm the township engineer in Falls Township, excuse me.
Okay, and do you hold any professional degrees?
I do.
What are they?
I'm a Bachelor of Science in Civil Engineering from Lehigh University.
Okay, and I'm showing you a document. Can you tell us what that is?
My resume or curriculum vitae is what it's called.
Okay, is it accurate and up to date?
Yes, it is.
And if I were to ask you more questions regarding your experience and qualifications, they'd be set forth in that document?
They would.
I'll admit that is Township Exhibit 5. And how long have you been the engineer for the township?
14 years.
And in the course of that position, have you become familiar with the township subdivision and land development ordinance?
Yes, I have.
And are you familiar with the property at 218 Lincoln Highway?
Yes.
And I'm showing you another document. Can you tell me what that is?
It's a letter of intent.
And what property does it address?
Burns Auto Center LLC, located at 218 Lincoln Highway, Fairless Hills.
And does that letter of intent indicate that the property will be used in any respect as a tow yard?
It does not.
I'm going to admit that as Township's Exhibit 6. To your knowledge, has any subsequent letter of intent been submitted with regard to that property?
Not to my knowledge.
And drawing your attention to Section 191, Section 5 of the Township Code, which is the definition section of the subdivision and land development ordinance. Can you tell us what the definition of land development is?
Any of the following activities. Want me to read them all, I guess. A, the improvement of one lot or two or more contiguous lots, tracts, or parcels of land for any purpose involving, 1, a group of two or more residential or non-residential buildings, whether proposed initially or cumulatively, or a single non-residential building on a lot or lots, regardless of the number of occupants contained. 2, the division or allocation of land or space, whether proposed initially or cumulatively between or among two or more existing or prospective occupants, by means of or for the purpose of streets, common areas, leaseholds, condominiums, building groups, or other features. Subsection B is a subdivision of land as that term is herein after defined.
And can you tell us what the definition of subdivision states?
The division or redivision of a lot, tract, or parcel of land by any means into two or more lots, tracts, parcels, or other divisions of land, including all changes in existing lot lines for the purpose, whether immediate or future, of lease, partition by the court for distribution to heirs or devisees, transfer or ownership or building or of a lot developments, provided, however, that the subdivision of land for agricultural purposes into parcels of more than 10 acres, not involving any new street or easement of access or any residential dwelling, shall be exempted. Subdivisions shall be divided into major or minor.
Okay. And turning back to the property that's at issue here, if the letter of intent that was initially submitted on September 11th of this year were to be amended, and it were to include that the use of the property would be to be used in part for the sale of used vehicles and in part for a tow yard under separate ownership, would that constitute either subdivision or land development or both under the definitions that you just read?
That would constitute both a subdivision and land development as indicated in the ordinance.
Okay. And as of this evening, are you aware of any application for subdivision or land development being submitted?
I am not.
And you're familiar with the current use of the property?
Yes.
Can you tell us how it's currently being used or was being used at least up until September?
Sale of used vehicles.
Okay. Was it also, to your knowledge, being used as a tow yard?
No.
Well, it was previously owned by Superior Motor Services?
When it was previously owned by Superior, it was a tow yard as well as minor repairs
Okay.
to vehicles.
And is that different than what's being proposed currently? Because it was under one owner versus two owners?
That's correct.
Okay, and would the two owners therefore require subdivision and land development approval?
Yes.
And have all your opinions tonight been stated to a reasonable degree of professional certainty?
Yes, they have.
I have nothing else.
I do have a couple questions. You realize that there's this, prior to Superior selling the lot, there was also sale of vehicles there as well, too?
Yes, that's correct.
Okay, so it wasn't just a tow and auto repair, it was also for sales, which is what's going on now, which is sales.
That is correct.
Okay. And you all, now, you may not be aware of this, but Mr. McCoy sold the property, which I'm sure you're aware of. However, he also signed a lease with the current owner as well, too, to continue to rent out the 10,000 square foot lot. Were you aware of that?
I have no knowledge of that.
That's what we're here for today, obviously, because without having a lot, we can't be on the duty tow. And were you aware that for the previous 5 years, Mr. McCoy has used the same lot, the same 10,000 square foot lot, for his tow purposes with regards to Fall Township duty tow?
At that location, yes.
Yes. And you understand that he's only renting it, not purchasing the parcel. There's not asking to subdivide that parcel for him to own that land. He sold that land.
That's my understanding.
And if the letter of intent, I believe Ms. Gallagher stated, if the letter of intent stated that there was going to be duty tow as well, and for storage for duty tow, that would be okay if it was in the letter of intent of Mr. Burns.
Okay.
It depends on what you mean by, I'm sorry, I was going to say the same thing. Depends what you mean by okay.
Would have met, well, it would have met your approval prior, not necessarily, because you didn't even, it seemed pretty clear, you didn't even know you were testifying today about this.
I learned rather late in the day. That's
Okay.
correct.
So if the attorney for Paul Burns' letter of intent included, oh, the 10,000 square foot duty tow lot was going to remain, would that change your opinion with regards to the necessity of a subdivision?
The definition of land development has been stated. If it's two occupants that are two different businesses, land development is required. When you say that it's going to remain, I'm not sure what that means.
Well, it's never left. The lot hasn't changed. The fence is still there. The 10,000 square foot lot is still there. It hasn't moved in the 5 years that it's been there. And that's what I meant when I said that.
Is there a question, Mr. Bradley?
So that, again, would that change your opinion? Because I understand what this, you read into the record what it says. She also asked for your interpretation of that. I'm asking you if it was changed in that letter. Would that change your opinion?
No.
Can I take a look at the one, you didn't give me a copy of that, of the, what you read off the subdivision? You haven't got a copy of that. If I could have a minute to take a quick look.
Certain.
Thank you. Nothing more from Mr. Sullivan.
I just have a couple of brief follow-up. Mr. Sullivan, just so that we're clear, the creation of the lease line between Mr. McCoy and, or I'm sorry, between Superior and Paul Burns is in part what's triggering the requirement to get the subdivision and land development approval? Is that
That's correct, yes.
And under the municipality's planning code and the Falls Township code, are you, as the township engineer, empowered to grant subdivision or land development approval?
I am not.
Who, and what body grants that type of approval?
The Board of Supervisors.
Nothing else.
Nothing further. This
Further?
witness.
Actually, at this point, we'll close the, I'm sorry.
Oh, no, I just had no more questions of him.
I'm sorry, I apologize, sorry.
I do not have any more witnesses, no.
Nothing more, okay. Okay, Mr. Bradley?
Briefly, Mr. McCoy would like to make a statement.
Good evening, gentlemen.
Is it appropriate to make a statement, or should he be questions?
He has an attorney, well, if he wants to make a statement, he can be subject to cross-examination. So I think it'd be fine to let him say what he wants, but he could be subject to cross-examination, and he needs to be sworn in.
And that's what I was.
Or, okay. I was saying, or you could wait and we'll do public comment after we close the hearing, in which case you could speak anyway. But-
Yeah, I think this is fine.
Okay, all right.
Do you swear the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
Yes. Good evening, gentlemen. James McCoy. When I did the sale of the property to Paul Burns, it was a minor oversight that he didn't put in his letter of intent that I would be renting the yard. I've been on the duty tow for Falls Township for 14 years, and at 15, I did it all by myself at over 800 calls with 5 trucks. I've proven my background and what I do for you for the township, and I'm looking for a little leniency here because I've been there 5 years. It's been zoned for 5 years. the same location. It hasn't changed, it hasn't moved. It's still auto repair, it's still auto sales. There's still a storage lot in the back. Just because the letter of intent didn't have it in there, I don't know where to go with it. I mean, I actually moved, obviously I sold when I moved up to Langhorne, but in the 010 amendment to the 206 record ordinance, we were grandfathered in. So we didn't have to have land development. We didn't have to have an actual office that functioned on the property, because we were grandfathered in the 010-206 record ordinance. Which is one of the reasons why I sold the property and moved to Middletown, because I was able to keep this storage yard and keep doing the towing for the township. Like I said, it was in our deal with the property. It stated in black and white that I keep the yard for 5 years as Paul Burns occupies the property. I have a lease from Paul Burns for 5 years that is signed by him, his wife, myself, have all parties involved. I think if you rule against this tonight and you take it away from me, you're going to be affecting the township as far as the safety of our officers, for our response times, for my crews that are out there 24 hours working our shifts. And we have been on tail with this for 14 years. I would ask that maybe we get a conditional use permit until Paul can amend his letter of intent, and if we have to go to land development, that can be done in a further date. But we've been there 14 years. Well, within a quarter mile of this building for 14 years. We've been at that location for 5. So nothing has changed other than ownership. And I have everything that I need here as far as the attorneys to prove the deal that we had. So I just ask you to consider all that, maybe get a conditional use for a couple of months until we get it all fixed. Paul Burns wanted to be here tonight. I texted him. He's probably like Jeff Dents. He's homesick with the belly flu, and sounds like he's dying on the phone. But he wanted to be here tonight to have, on my behalf. So, I mean, that's pretty much all I have. I've been on township a long time with you guys, so a little leniency, if you could, would be very much appreciated on my end. Thank you.
Thank you.
You're subject to-
I have no
Oh,
questions.
okay. You're good, now you can sit down. The only thing I would put out, Mr. Commissioners, is that in the 5 years he's had that contract at 218, nothing has changed. It's the same lot, it's the same fence, it's the same entry point, exit point, nothing has changed. You know, my client has a history of no violations in that time frame with regards to the duty tow, you know, regards to going in and off of that property. He's been nothing but a good neighbor while he was there. His decision to sell had nothing to do with the duty tow. In fact, it was just a business decision he made at the time. And that's why we're here today arguing for the continuation of the 2018 list.
Okay. All right, thank you. Anything else, Mrs. Gallagher, from you?
Not this time, no. This time it would be appropriate for the board to close the public hearing, see if there's any public comment, and then take a vote as to whether to approve or deny the license application.
Okay. All right, thank you. Is there a motion to close the hearing?
So moved.
Second.
All in favor? Aye. Any public comment? Okay. All right, so board, obviously you can ask questions of Ms. Gallagher at this point, or just in general, I guess, or have specific comment regarding whether or not to deny the application for Superior Motor Service for the Wreckers List 2018 calendar year. Mr. Galloway?
No questions.
Mr. Boraski?
I have a couple of things. So first, Mr. McCoy, I share the same concern. I mean, your service has been excellent to the township and what your company provides. So I'm concerned kind of the same situation. So let me ask, with the letter of intent, even with Mr. Burns turning that letter of intent in, would they still need land development?
Yes.
So he couldn't, so like Mr. McCoy has a lease with him to use that lot. And they agreed upon it, they signed that lease. He can't let them use that without a letter of intent?
It's not necessarily the letter of intent. The letter of intent is what, and the submission of the application was what drew this to our attention. But the lease of the portion of the property divided the space between Mr. Burns and Mr. McCoy, and that's what triggered the need for subdivision and land development approval. So the letter of intent, whether it's amended or not, there's still subdivision approval required.
So can you allow your business, like another business, to use your property to tow cars to it?
Not without having subdivision and land development approval.
Our ordinance is very specific with respect to if there is a piece of property, one parcel, that is being used for different uses, you need subdivision and land development. You may recall a few years ago, we had a situation with a building that the former owner of the, or the owner of the building wanted to divide it up between 2 or 3 different businesses. They weren't doing any physical changes, but there were going to be different uses in the building. They had to come to us for land development. It's the same thing here with this property.
That was the pathmark.
For subdivision and land development, yeah.
And
So
I
you,
was going to say, the problem is that Mr. McCoy has to have this property before, or when he applies, he has to have it, or before January 1st, he has to have it?
He has to be able to demonstrate that he can legally use the property on or before January 1st.
Right,
And
and
at
the
this
problem-
point,
Right, there's no way to do land development allocation of space between now and then.
correct.
Mr. McCoy being grandfathered in, whatever that term is for, he's,
The use of the lot is not
doesn't
really.
affect this?
The zoning and the use of the lot is not a problem. Mr. McCoy did go and get variances in order to be able to use the property. It's really just the allocation of space that requires a subdivision and land development, which needs to be in place before the property can be used.
So, legally, what does it open us up for if we were to give him some kind of conditional use?
Well, there is, and we dealt with this actually a couple of years ago, and in the exact opposite situation, there is a property interest that attaches to these licenses, and the companies that submitted their license applications on time, complete, and have a demonstrable ability to use a property within the township could potentially have something to say about that.
So I have,
Mr. Rocco?
So Mr. McCoy didn't need to go through subdivision because he was the same owner when,
Previously, correct.
okay. But because there's 2 different owners, that's the process.
Correct. There's a lease line on the property now.
And even if there's not technically 2 different owners, one owner, but one person is leasing it from that
Correct.
owner.
Oh, right.
Yeah.
Correct. It's 2 different businesses.
So it is like
Yeah.
the issue with the old Pathmark, where one person owns the whole building. They
Allocation of
lease
space.
they lease within it. There's allocation of space.
Because I would point out, 218 was not owned by James McCoy or by Superior Motor. It was owned by 218 Lincoln Highway LLC, who leased it out to Superior Motor. So for those 5 years, that's how it was as well, too. So technically, there was an owner, and it was the same landlord-tenant situation, which is the same as here, just 2 different owners.
But the issue is you weren't dividing up. If 218 LLC had created a separate space within the building, even not even outside the yard, within the building, for a separate business to sell tires, that would be an allocation of space, regardless of who owned it. Okay.
did the towing and the repairs and the car sales all the same company?
No.
Who owned 218 LLC? Who was the principal owner?
Robert McCoy was a principal as well, too.
There was no lease lines. There was no division of space.
Mr. Rocco?
Mr. Sullivan, how long does a subdivision of land usually take if it's clean?
Something like this could go very quickly. They could be at the planning commission in January and in front of you guys in February, if everything was okay.
Which it never is.
Which was also a reason why we were asking for some sort of conditional use, since it was a short period of time. Unfortunately, I don't control that because I don't represent the owner anymore. So I have to get the owner to actually go ahead and do this. That's an issue, and which is why it's a shame Mr. Dillon left, because he represented Paul. He's Paul Burns' attorney right now, while Mr. Hecker is convalescing.
Yeah.
Which is why I think he left quickly. Because that's why he got out the door quick.
All right. So I think it was 2 years ago, we had somewhat of a debacle with, other towers or wreckers, whatever we're calling them, getting their applications in late. Actually, I think that was somewhat our error even. Possibly, I think the wrong date was on it. So it was unfortunate that, we had to make a ruling on that, knowing that if we did go in favor of them, there was likely going to be a lawsuit. And I can't imagine if we were in favor, I don't know if you guys are, we wouldn't have to go through this, lawsuit with the rest. We've been sued prior by the wreckers, right?
That's correct. We were, excuse me, 2 years ago, there was litigation due to the board's decision to deny the applications for several of the tow truck companies in the township. The township did prevail in that litigation. And I believe the early 2000s, there was other litigation which established the property interest in these licenses.
In the last litigation.
That was not victorious in that one.
We were
I
dragged
wasn't
in as
here.
well.
That was before
We
me.
were not.
So, we were dragged in that litigation as well a couple of years ago. So,
Yeah.
I mean,
Yeah, right.
everyone in the room spent a lot of money as well on that one. That did end up, going our way. That was actually a couple Christmases ago, I remember. It was,
I believe
it
we
was
were
in
served on
between the
Christmas Eve.
holiday season, right in the middle, yes.
Yeah. That's all I have.
Yeah.
Can I ask one more
Sure,
question?
absolutely.
So, if we deny Mr. McCoy, can he go can he sue us or take us to court for that?
Yes, he can.
So, if he was to do that, and still go through land development, would that apply to that ruling or no? Does that make sense?
If he were to challenge, if you were to deny,
Yeah,
and he were to challenge it in court,
Yeah.
and the judge was to make a ruling putting him on the tow list,
And he had done land
and he
development
had
in the
done land
meantime.
Right, and
Yeah.
he'd done the land development in the meantime, then, well, I won't tell Mr. Bradley how to handle this matter, but obviously, if the land development has been completed by the time you go to court, you're gonna be in maybe a little stronger, position on their part. But, if a judge makes a ruling, and the judge puts him on the tow list, it doesn't matter what he does with respect to the land development and the subdivision.
so, that's all I have for now.
You want to say something, Mr.
I mean,
McCoy?
personally, I'd rather not sue anybody or go to court about anything. I just want to continue on the business that we've done. And as you guys reflected back to the issues with the other towers, when all that went down, it was crazy. I had 2 weeks to go spend $500,000 and buy enough trucks to cover you guys for a full year by myself. And I ran 24 hours a day. My fiance's in the room. She didn't sleep for a full year. That phone rang every 20 minutes, whether I was on vacation or if I was down the shore, or if I was in bed. She didn't sleep awake. I'm just verbatimly asking for a conditional. I've spoke to Paul Burns repeatedly today via text message and on the phone. He has no problem. He said, whatever we need to do, Jim, we have a contract in place. If he has to commit for land development, him and I will stand here arm in arm, and we will get it done. So,
Okay.
that's pretty much where I'm at. I appreciate you guys' time.
Sure. Yeah, I think, certainly, Mr. McCoy, we've known you. You have been, a very good businessman in this township, and you've done a good job as a tower, which is not always something we can say, quite frankly, to people on the list. The problem is, of course, that what we've been referencing, you referenced yourself a few years ago, where there was, partly an innocent mistake here in the township, where the information about turning in towers licenses was mailed out in the same mailing as the business license was mailed out, thinking that it would be, nice and convenient to receive one letter instead of two. The problem was that a lot of people didn't look at it. You did. And you were, quite frankly, the only business that saw it and applied and put everything in on time, and no one else did. And the problem we faced was certainly, we could have been blamed on us, and certainly people blamed us. It was not done, in a kind of sinister way, which is some people accused us of, trying to benefit you by sort of, rigging the system or something. And you did work the whole year. and did certainly a very, very good job in terms of, it may have even been a year we had a really bad winter and we were towing cars, from snowing lanes and things like that. The problem was, and you've referenced, your time here, 14 years or 15 years on our tower list. There were a couple businesses that had been on our tower list longer than that. I think Falls Auto Body was one that had been maybe for 30 years, had been towing. And they haven't been on our list since because they got kicked off and they had never been able to find another lot. There's a couple other towers, and you're well aware of this, that haven't been back on our list because they haven't been able to find another lot. And I do remember, and it's coming back to me, and it's sort of like, it was, right, Mr. Bradley, it was this time of year, and it was not a fun meeting to go through because we knew it was a very, very difficult situation. But I do recall that, you were certainly on the opposite end of this because you recognized the fact that you would be the only game in town. And certainly while you did have to spend the money to go out and get more trucks, and certainly the phone kept ringing, you also collected every bit of money from all the towers. And so it certainly helped your business a lot. And that was something that you would have had, and you did have, a vested interest in, that if we had decided to say, you know what, it was our fault, we're going to let everybody on the list, you would have sued us. And I think Mr. Bradley was even making, references to that a couple of years ago, saying, look, you're going after the property rights that you're going to be entitled to because you follow the rules. We're in the same situation now. Obviously, you're on the different side now. And it is unfortunate. Like I said, this isn't, I hope you understand. I believe you do. This isn't anything personal.
Case in point is that the property is still zoned for that use.
I know.
So land development, as Mr. Sullivan said, would go rather quickly.
There's a variance that attached to the property.
Yeah.
Several years back.
Yes. Yeah, there's a variance that applies. So I see the township in the same exact situation. It's just that you're unfortunately on the other side of it this time. I don't, in my opinion, just myself, I don't think we have an option but to abide by what the law says. And I know it's a technicality, and I know it hurts you, and I apologize for that. Obviously, it's nothing personal, but a couple of years ago, it hurt everybody else, and you were the beneficiary. The good news of this is that you already
our
have,
officers were the beneficiaries because they were safe.
But
I was out there in my scheduled response.
But and I certainly we do a good job, and our police department does a good job of verifying the backgrounds of and records of all the towers, and knock wood, our officers have been safe and will keep that way, no matter who's towing for us.
Okay.
God willing. But the issue here is, I don't know if we have an option but to just abide by the law. And as I said, the benefit you have is you have a property. You can go through land development. You certainly can keep operating in different townships. I don't know what their rules are, and you can keep the tow yard. And so this time next year, you should have absolutely no issue in terms of getting on, because you have the property. Other towers haven't been able to find any.
If I was removed off the list, I would lose my grandfathered rights, which means then next year I would have to come back with a full functioning business in the township and a yard. We are grandfathered in, so we don't have to have a functioning business on the property, and it's in 206E in the record ordinance. So if I do lose and I do get kicked off, or if I'm removed from the list, it starts all over. So I have to.
I'm not totally sure because we have.
It's in there.
Pendle Towing doesn't have an office in Falls Township. They have a yard in Falls Township. Is that correct?
Correct. There's only, the ordinance just requires, pursuant to B4, that there be a vehicular impound lot within the township and that it be actively used to secure vehicles towed in the township.
I don't believe your office has to be in the township.
Well, that was the original ordinance. And again,
It's not required in this.
It was amended back in 2010. Actually, you guys amended it.
Rob doesn't. Well, Rob's has been grandfathered, but.
Well, Pendle has a difference, so they're running heavy only.
A lot.
Yeah, I'm not. Yeah, I'm.
A lot in the.
Pendle has a lot in the township.
But Mr. McCoy's saying Pendle was grandfathered in because they've been on the list so long. I don't. But
Pendle and Rob's were both part of the issue back in.
Correct. They were off. You're right.
14, I think it was.
So the grandfather would have gone away.
Correct.
Yes, Mr. McCoy. I think.
Getting one.
The people who went off the list and have not been able to get back on are the people who don't have yards.
Yeah, don't have
in the
yards.
township.
Right, right. So you don't have to have an office.
Well, here's one more question I have then. If we decide to delay.
Any way we can put this on next month's list? Give us a chance to go to land and subdivision and give us a time. If there's no vote, it's still open. Obviously, 1/1, he doesn't go on, but at least it doesn't make him wait until 1/19.
Well, the other question is too, if we do get subdivision, come back and get adult done, will I still be allowed to get back on the list in 18, or is that closed until 19?
The list is closed until 19.
no.
Right, and there still would not be access to the lot legally on January 1st.
And that's what our ordinance
Yeah,
requires.
Unless
but you
we
have to
get
have, you have to have the ability to use the lot for the towing of vehicles.
Unless
Is that
we
your
get a
first-
conditional
and you
use for
can't.
2 months.
But again, you're asking us to sort of bend the
No.
law, and 2 years ago, the other guys were asking us to bend the law, and we didn't.
But, yeah, but the property's still zoned for the same
I
thing. Just
understand.
because it's under a different name, different
Yeah.
person owns it, it's still there, functioning.
I know.
Ms. Gallagher, we talked about moving this vote till January 16th unless we were given that opportunity.
You were given the opportunity to continue the hearing, but the hearing was still going to be to determine whether or not there was access to a lot as of January 1st. It was not to,
Then that's,
I have no choice.
just go ahead.
Okay.
Just go ahead and so.
Any other comments or questions, board members?
None.
None.
Ms. Gallagher, anything from you?
nothing. It would just be appropriate to see if there's any public comment, and then a vote would be in order.
I thought I opened up, I think, before, didn't I?
Oh, did you?
Yeah, I
I'm
opened up
sorry.
before. Yeah, that's fine. That's fine. All right, looking at item number 4, consideration of the application for Superior Motor Services. The chair will entertain a motion at this time.
To deny would be to,
They would not go on the towers list beginning on January 1st of 2018.
I make the motion to deny.
Motion made. Is there a second? I'll second. Motion made and seconded. All in favor?
Aye.
Opposed? Okay, all right. Mr. Coy, I'm sorry. Unfortunately, it's, technicalities are technicalities. Unfortunately, they cut both ways in this case over the last couple of years, so we hope to see you back here next year on our list. All right? All right, item 6 is consider adopting 2018 budget and resolution establishing the millage for rate for 2018.
The preliminary budget for 2018 was presented to the board on November 21st. This budget has been advertised and on display. At this time, there is a resolution for board consideration to adopt the 2018 budget. Also, Ms. Rukoff and I are here for any questions you may have.
Okay? All right. All right. Comments or questions from board members for Mrs. Rukoff or Mr. Gray? Mr. Galloway?
None.
Mr. Boraski?
No.
Mr. Rappel?
I have none.
Okay. Is there any public comment on the budget? Mr. Mariani? Is there a motion to open public comment?
So moved.
Seconded?
All in favor?
Aye.
That time of year, so let me wish everyone a blessed Christmas and peace on earth to men of goodwill. Now, host fees continue to be the major source of funding for our budgets. This year, again, as it was in 2017, it's going to be $14,800,000. And again, I've been saying this for years, normal operating expenses should be supported solely by taxes. This reminds taxpayers of the real cost of government and acts as a restraint on unnecessary spending. Further, making long-term commitments on host fees, I think, is a very risky business. Now, I just have a couple observations on the host fund, but in the interest of time, I don't think, they have to, my observations have to be addressed tonight. I made a copy of them with the account numbers, and if you like a copy of that, I'd be glad to give it to you, and then you can answer at another meeting or a couple of meetings from now.
Okay.
A couple observation was the fund reserve available was roughly 4.6 in 2017. It's 2018 now. That's a decrease of about $3 million. The fund balance restricted at $30,964,967 hasn't increased in 5 years. but the fund reserve restricted, which is the same number, showed an increase, an even increase of $2 million for 2018. The $15,970,000 transfer to the general fund, that includes the $14,800,000, the $950,000 from the resource recovery fee, but it also includes $220,000 from long-term restricted. The capital purchase township building was $45,000 in 2017. That was $260,000 projected in 2018. That's an increase of $215,000. The local service tax revenue of $400,000, which would be an average over the years, in 2018 is projected to be $680,000. That's a $280,000 increase. Now the pension fund, Ms. Brukoff mentioned, it continues to rise. The trajectory is out of this world. I think it's doubled since 2012. Now, to help control this cost, I'm going to continue to encourage its township to match 50% of an employee's contribution for the first 6% of salary that an employee contributes. And that's going to ensure the township that you will not match more than 3% of an employee's salary. That gives you some kind of control. Healthcare, employees expect healthcare costs to increase by 5.5%. For 2018, that's up for 4.6% in 2017. Our proposed budget, the increase appears to be 7.3% for the township. We're, again, way ahead of the industry in that kind of stuff. Kaiser Family Foundation reports an average annual family premium per enrolled employee for employee-based insurance, I'm not going to go into the other years, we'll just stay with 2018, is $19,796 for the employer contribution, $6,028 for an employee contribution. For single, it's $66.90, and employee contribution, $12.13. Tower Watson reported, this is what is going on in private industry right now. 53% of employees will remove subsidies for spouses and dependents. 41% of employees, they're going to just cap everything with a flat dollar amount. In an effort to control costs, 84% of employers offer high deductible plans, and 35% of that group offer high deductible plans. That's the only plan you can get. I don't think we have any deductibles in our plan. Our costs are well beyond industry, and I think well beyond what is reasonable, and unless I'm mistaken, we should be somewhere right now around 42,000 or 43,000. If that's the case, we can't justify that cost. We just can't. We got to get that under control. Overtime was another observation. I don't understand why overtime is budgeted at such high expected levels of use. Was last year, again this year. I don't know. I would take a look at how many employees are involved, and does it mean we need a new hire or maybe some part-timers to fill in? The one change I'd like to see would be an employment system and standards that we have here in our township. And this is something that our employees would like. You're giving everybody a raise of 2.5% or 3%, whatever it is, of the previous year's salary across the board. That tells your best and your poorest employee their performance doesn't matter. That's what happens. Salaries should be based on qualifications, skills, experience, and performance, and that against a job description, and not on seniority or longevity, And the job description becomes the cornerstone of what I'm trying to change. You set a pay grades, you get a minimum, a middle, and a maximum for each job description. You let everyone know and understand the pay grades and what each employee has to do to earn the highest grade. This system bases salaries and raises on merit and rewards excellent performance. It's great for the employee. It's great for us. The proficiency you're going to get from your employees is unbelievable. Employees' earnings then are no longer hindered by time and grade, which they are now. The beginning of the year, you budget a certain amount for increases, and you do that at the beginning of every year. That's it. Now you know where you stand, okay? 2 quickies. This budget, consider new township complex. I'd like to see us consider that. Begin a feasibility study. We can do that. And that feasibility study, based on an addition and a renovation to this existing building. Doesn't have to be like the one I had favored, phase 4 or whatever. An addition and a renovation, we can do it. I think we could afford it. We could probably do it at half the cost it would have cost us to tear this down and rebuild it. Now, I believe that. And finally, here it comes. Budget for vacuum leaf collection in 2018. Listen to me, hey. Get your pencil out. You like statistics. I'm going to give you real fast statistics.
I'm a history teacher. I'm not a math teacher.
The United States Census 2016, because they have 5-year estimates.
Sure.
Okay. Ages 60 to 64, 5.6% of our population. 65 to 74, 8.1% of our population. 75 to 84, 4.4% of our population. 85 and older, 1.5%. Now we're almost 20%. We are almost 20% of Falls Town's population, 19.6. That doesn't count for all the young people that want this service. So, listen, all you people at home, especially your seniors, take a good look at this board, and if these people do not budget for the vacuum leaf collection wherever you see them, in church, at a restaurant, at a store, stare at them. Merry Christmas.
Merry Christmas. Thank you. Okay, any other public comment regarding the budget? If not, is there a motion to close public comment?
So moved.
Second.
All in favor?
Aye.
Okay, so we have Resolution 1721, correct?
31.
31, I'm sorry. Resolution 1731. That would, okay, I thought we did. Okay, yeah, sorry. That would establish a millage rate for 2018. So we're doing 2 things. We're, number 1, voting on adopting the budget, and then number 2, voting on the resolution establishing the millage rate. If there are no more comments or questions from board members, is there a motion to approve the budget for 2018 as it is presented?
So moved.
Second.
All in favor?
Aye.
So will the budget be up? It'll stay up on the website?
Yeah, absolutely. It'll always be up.
And then Resolution 1731, establishing the millage rates. Is there a motion to approve that?
So moved.
Second.
All in favor?
Aye.
Okay. Thank you again, Mrs. Rukoff, Mr. Gray, all the staff that worked on the budget. Mr. Morandi, thank you for your comments as always. We do talk about there's definitely things. We're actually disappointed. We went all through the fall, and almost here we are like a day shy of winter. And when you had this is the first time we brought up the leaf truck. We had an over/under sort of like on when that was going to come up. We sort of thought maybe you forgot, but never forget. Okay. Thank you. All right, item number 7 is consider awarding workers' compensation contract for 2018. Mr. Gray?
The township has received a quote for workers' compensation insurance from Vaughn Insurance for the year 2018. The quote of $473,852 is from Delaware Valley Workers' Comp Trust and the State Workmen's Insurance Fund. also known as SWIF. SWIF is used for the volunteer fire coverage. The township has used Divot in the past as its work comp carrier since 2003. As a comparison between Falls Township and Bristol, for 2017 premiums, Bristol paid just roughly $569,000, and Falls Township $467,000. In addition, the township receives grants from Divot. They do give us a dividend each year. This past year, we received $28,000, and they also provide safety training and seminars for the township employees. The board is asked to consider Divot and State Workers Insurance Fund for Falls Township's 2018 workers' comp insurance coverage in the amount of $473,852.
Okay, comments or questions from Mr. Gray?
No questions.
I just want to comment because of the comparison. Is the township Bristol compared to Falls? Like when you're talking workers or size of fire departments? I just want to know where the comparison came from because it seemed to be a bigger township and I don't know about fire services maybe.
They do have a different amount of employees, and yes, the fire companies, everything that we have is compared to them.
Okay.
They are different numbers, of course, but these are just the comparisons
far
of
as-
the premium.
You know, employees and volunteers and volunteer firefighters?
Yes.
Okay, thanks.
Questions?
No, I've none.
Okay, public comment? See no hands. All right, is there a motion then to, what's the award the workers' compensation contract for 2018 to Delaware Valley Workers' Compensation Trust and the State Workmen's Insurance Fund, and the amounts outlined in the December 14th, 2017 memo by Mr. Gray.
So moved.
Second?
Mrs. Pullen?
Mr. Galloway?
Yes.
Mr. Boraski?
Yes.
Mr. Harvey?
Yes.
Mr. Rocco?
Yes.
Okay, thank you. Item number 8, consider restricted covenant agreement for the Quaker Penn Park. There were various improvements made to Quaker Penn Park over the past year, and it was done using open space money from the county. And when that happens, part of the agreement using open space money from the county is that you have to restrict wherever you use that money and keep it open space. This is obviously not an issue because it is a park and we're not really planning on doing anything with it except keeping it a park. But we do have to follow through and designate this, or approve, I should say, this restricted covenant agreement. Mr. Gray, anything I missed with that?
No, the covenant has been prepared for board consideration, and once we adopt this, we will forward this to the county and eventually receive the funding for the open space project.
Okay. Ms. Clark or Ms. Gallagher, anything from you?
I think you covered it.
Okay. All right. Comments or questions from board members?
No.
None.
Okay. All right. Is there a motion then to adopt the restricted covenant agreement for Quaker Penn Park?
So moved.
Second.
It's not a resolution, correct? It's just a contract or
Yes.
agreement? Okay. Motion made and seconded. All in favor?
Aye.
Okay. All right, number 9, number 9, rather, consider authorization for advertisement for the trimming and removal of ash trees in Falls Township. All right, Mr. Gray, why do you not like ash trees?
I like them, but unfortunately, certain insects do not. The board is asked to consider authorization to advertise for tree trimming and removal at township facilities in 2018. This is necessary to the emerald ash borer that is killing ash trees. This insect was first discovered in Pennsylvania in late 2007 and has been slowly making its way across the state. We have identified several dead ash trees in our parks that will need to be removed, and we anticipated identifying more in 2018. Bid specs have been prepared, and at this time, the board is asked to consider authorization to advertise.
Okay. All right. Questions or comments, Mr. Gray?
None.
No.
So we've identified some trees, we're gonna identify some more, and then in the spring, we'll have them take them down, or?
Yeah, well, the game plan is to have the ones that we've already identified, eventually get those down sometime in the spring, and then I'm sure we will find more next year as well, and then we will have somebody on board for the service, and we'll ask them to take down those future identified trees.
Let me ask them to remove the stumps too, I think.
Yes, ground them down, get it all down to the ground.
And it's, is it only at Community Park?
It could be anywhere in the township, any of our properties.
The ones that we've already identified, are they just at the Community Park?
Yes.
Okay.
And we're anticipating the cost being in excess of the bidding threshold?
Yes, we have budgeted, I believe it's upwards of $60,000 to $80,000 for this service for next year.
Okay. All right. Comments or questions from the public? Okay. And this is just motion to advertise for, put out the bid specs basically for companies to bid on this.
There's no responsible contractor for this. This is all just open bid?
This will be a sealed bid. It'll be open.
Well, yeah, I know, but I mean, do we?
No.
No, there are probably no craft employees required for this
Yeah,
effort,
okay.
so.
Right.
Charters.
Okay.
Okay. All right, is there a motion to authorize advertisement?
So moved.
Seconded?
All in favor?
Aye.
Okay. All right, and number 10, consider purchasing 4 laptops for the Falls Township Police Department vehicles. Mr. Gray?
The police department would like to purchase 4 laptops for use in the vehicles for a cost of $4,915.96 each. These will be installed in the marked police vehicles. They will replace units that are 7 to 8 years old. Total cost of all 4 units is $19,663.84. These laptops are included on the Federal Cooperative Purchasing Program administered through GSA. This is a similar program such as CoStar's. The board is asked to consider this purchase. In addition, Lieutenant Pletnick from the police department is here for any questions.
Okay. Questions for Lieutenant Pletnick?
No,
Ernie?
I don't think so.
Well, now, if you have anything to add to Mr. Gray's?
I do not, except succinctly.
Okay. All right, any comments or questions from board members?
No.
Okay. Yeah, laptops that are 7 or 8 years old. I'm not the computer expert up here, but that seems kind of old. For,
Yeah.
So, all right, total cost $19,663.84. Any public comment? Seeing none. Is there a motion? Is there a motion then to purchase the 4 laptops for police use in the amount $19,663.84 from BMS?
So moved.
Second.
Mrs. Poland?
Mr. Galloway?
Yes.
Mr. Boraski?
Yes.
Mr. Harvey?
Yes.
Mr. Rocco?
Yes.
Okay, which is now getting into the Jim Sullivan portion of our program. Okay. Items number 11 and 12 deal with change orders for 2 projects that are, one's finished, I believe, and one's still ongoing. So Mr. Sullivan will allow you to talk about each of these, and then we can take them one at a time in terms of the change orders.
Thank you, Mr. Harvey. Yes, the footbridge has been installed. It is complete. The fishing pier is under construction. Due to ongoing negotiations with the contractor, and there's some items in the bid that didn't have to be completed, there are 2 change orders, one for each project. For the fishing pier, there was a decrease of $8,000, but we decided to go with cedar as opposed to some other kind of stuff for the deck. And that was an increase of $3,600 for the cedar, giving us a net decrease of $4,623. For the footbridge, the notice of award was issued to the contractor with the idea that there would be a change order. And again, there were things, E&S controls, and they came in a different direction, which cost a lot less money. So that was a net decrease of $26,529.68. So 2 change orders in the correct direction, resulting in credits to the township.
Yeah, so a total of about $32,000 in the plus for us.
That's correct.
Yeah, okay. All right, thank you. Comments or questions for Mr. Sullivan?
The footbridge looks great, and I'm sure everyone in Vermilion Hills really appreciates it. Thank you.
I have nothing.
Okay.
I'm not sure I've seen many decreases, change orders, so.
They don't happen all the time, but
Yeah.
Yeah.
I would say so.
this is good.
Nice, nice work, thanks.
Yeah, my compliments to Mr. Jones and his hard work on this.
Of course.
All right, so we'll take these, I guess, one at a time. Is there a motion then to consider the change order for the community fishing pier, which is in the amount of $4,623 back to the township?
So moved.
Seconded?
Okay, all in favor? Aye.
Aye.
I should have taken, I'm sorry, public comment, is there any public comment needed? All right, didn't think so. All right, and next, is there a motion to consider the, or adopt the change order or accept the change order for the Vermillion Hills footbridge project in the amount of $26,529.68, again, back to the township? Motion for that?
So moved.
Second.
Okay, all in favor? Aye. Okay, thank you. That's good news. Minutes for the 21st of November. Any comments or questions, corrections?
I got nothing.
Okay, if not, is there a motion to accept the minutes as presented?
So moved.
Second.
All in favor?
Aye.
I abstain.
Okay. Back to Mr. Sullivan, engineers report. Okay, you got a little bit of a break today. Mr. Dents isn't here, so.
Thank you, Mr. Harvey, and I didn't want to say too much about the fishing pier during the change order because that would have taken everything away from me. The engineers report. All the piles are in place. And we just had a little conversation about what kind of material the pressure treated wood would be. We've come to an accommodation on that. All of the shop drawings have been approved for the connections and the wooden material. So we assume either tomorrow or the next day they'll be able to begin foundation framing in earnest, and then finish with the cedar decking at the top. Other than that, that's all I have.
Okay. Comments or questions for Mr. Sullivan?
None.
Okay, I do know that, remember talking to the manager earlier today, is the issue with trees on Walton in terms of the trees that are supposed to be put in. I know we're working on that, and I think we
Yeah,
have
all the residents have been given stakes to show exactly where they wanted to put trees in. I think landscaper was supposed to put them in last week. It was scheduled last week. That did not happen. Mr. Gray was going to call him and find out what the new schedule was.
Okay, and I guess we're waiting for a call back?
Yes, I'm just waiting for a call back from the contractor.
Okay. All right, thank you. Okay, any public comment? See no hands. Okay, is there a motion then to accept the engineer's report for November 2017?
So moved.
Seconded.
All in favor?
Aye.
Okay, bill list for this month is in the amount of $1,846,173.24. Of that 1.8, almost 1.9 million, about 1.2 million is salary and benefits. Additional about 20,000 for health insurance, as well as about 20,000 in escrow, and about 60,000 in state funding that we get that reimburses us for various things, highway, police functions, et cetera, et cetera, et cetera. Questions or comments regarding the bill list?
None.
None.
Okay, public comment? See none. Okay, is there a motion then to pay the bills, $1,846,173.24?
So seconded.
Mrs. Pullen?
Mr. Galloway?
Yes.
Mr. Brasky?
Yes.
Mr. Harvey?
Yes.
Mr. Rucker?
Yes.
Okay, executive session we had before the meeting. Police chief's report. And the chief isn't here, but we have Lieutenant Pletnick here. Give us a report.
Good evening, everybody. Sorry Chief Wilcox couldn't be here. He asked me to read the report for him. Keep this short. 2017 has been a very good year for the police department. The police department did achieve most of its goals and objectives. More importantly, no officer was seriously injured during the year. Community policing continues to finish out their graduations. Tomorrow, Penring Dare graduates at 7 p.m. and Eleanor Roosevelt School on January 4th at 7. St. Michael's is still being rescheduled.
The microphone.
Yeah, I'm sorry.
I'm sorry. St. Michael's is still being rescheduled. So anyway, to backtrack a little bit, Penryn tomorrow night at 7, and Eleanor Roosevelt.
January 4th.
Oh, January 4th, I'm sorry.
It's all right.
The Police Chief for a Day program is restarting on January 10th. Coffee with a Cop is planned for an undetermined date in February at the Senior Center. The Citizens Police Academy is scheduled to graduate on January 16th here at the Supervisors meeting. A drug take-back has been scheduled and a shredding program tentatively for Saturday, April 28th from 9 to 1. That may change depending on what the DEA, we haven't gotten a specific date for the DEA, but they generally do it on the last Saturday in April. That's it. I have nothing else at this time, and I thank you very much.
Okay, any questions for Lieutenant Plotnick?
None.
No.
None.
Okay. I guess the only thing, is there any, in terms of, this is always sort of a season with people shopping a lot. We get a lot of, sometimes people forgetting to lock their cars at some of the shopping centers and vehicle break-ins and that kind of thing. You know, we'd like to let people know if there's any sort of trends that are happening there in terms of any kinds of vandalism, break-ins, anything really kind of going on in the township regarding
I
that?
have been doing the paperwork the last 3 weeks consecutively, and there has been sparse incidents of any cars being broke into. We still are putting drop cars, dummy cars, at certain locations throughout the township to deter car break-ins and whatnot, so that program is still in effect. And it has been pretty quiet, knock wood, so far this holiday season.
Okay. All right, thank you very much.
All right, thank you.
Appreciate it. Okay, manager's comment. Mr. Gray?
Yes, thank you, Mr. Chairman. Just a few items tonight. Township has 8 escrows for release at this time. They include T-Mobile for $9,568.10, a second T-Mobile for $3,830.28, Verizon Wireless at 417 Hood Boulevard for $803, a second Verizon Wireless for $3,576.45, Lubricycle, also known as New Seaview, at 150 Solar Drive, $900.92. Planet Fitness on Plaza Boulevard, $1,530.76. OmniPoint, 417 Hood Boulevard, $7,930.23. And finally, Day Spring Electric, 418 Tyburn Road, $5,932.50. These escrows have been reviewed. T&M is satisfied with the work that was completed. The board is asked to consider these 8 escrow releases.
So these essentially look like just a lot of accounts that were just sort of forgotten about for a while, and now people are saying, well, you know, we still have money left in there. And
Yes, these are older escrow accounts. These are jobs that are completed. These were done several years ago.
Okay.
So Lubricycle, they never did anything, right?
No, they withdrew their application.
So that's some money that they,
Right.
yeah.
Yeah. Okay. All right, we're just going to do all these at once. Any comments or questions regarding any of these?
No.
None.
Okay, is there a motion then to approve all 8 escrow releases as outlined in the December 13th, 2017 memo from Mr. Gray?
So moved.
Second?
Mrs. Pullen?
Mr. Galloway?
Yes.
Mr. Bransky?
Yes.
Mr. Harvey?
Yes.
Mr. Rocco?
Yes.
Township received a letter from Mr. Sullivan regarding escrow release number 12 for Morrisville Commons. In his letter, he is recommending an escrow release of $95,766.75. The board is asked to consider escrow release number 12 for Morrisville Commons.
Comments or questions?
None.
Motion to approve the escrow release number 12 for Marsville Commons?
So moved.
Second?
Mrs. Pullen?
Mr. Galloway?
Yes.
Mr. Bransky?
Yes.
Mr. Harvey?
Yes.
Mr. Rocco?
Yes.
Township received another letter from Mr. Sullivan for St. Joseph's Court, escrow release number 1. This is in the amount of $83,211.97. The board is asked to consider this escrow release.
Comments or questions?
No.
No? Okay. You know, rather, instead of voting on this one by itself, the next one by itself, we'll just, want to present the next one too? We'll just vote
Certainly.
both of them at the same time?
Next one is escrow release number 5, Marmar Builders. This is for $135,947.17. Board is asked to consider this escrow.
Okay, comments or questions regarding this one?
No.
No? Okay, is there a motion then to approve these 2 escrow releases, St. Joseph's Court and Marmar Builders?
So moved.
Seconded.
Mrs. Pullen?
Mr. Galloway?
Yes.
Mr. Bransky?
Yes.
Mr. Harvey?
Yes.
Mr. Rocco?
Yes.
Just want to announce some new businesses that opened in the month of November at various locations throughout the township. Rite Aid, located at 547 West Trenton Avenue. Tip Tap Toe Dance Academy at 203 Lincoln Highway. Blue Man Plumbing, 15 Tulip Lane, B&D Auto Sales, 135 Lincoln Highway, Beef Jerky Outlet, 110 Lincoln Highway, Commercial Trailer Leasing, 225 Lincoln Highway, Gold Star Contracting, 168 West Trenton Avenue, and Brown's Vending, located at 225 Lincoln Highway. I do have for board consideration a memorandum of understanding for 3 of the township's police department's lieutenants, Lieutenant Ward, Lieutenant Pletnick, Lieutenant Airy. This memorandum of understanding is for a term of 1 year, and the benefits will remain in effect that are currently in the 2017 contract year, will remain in effect for 2018. Board is asked to consider this memorandum of understanding pending a legal review.
Okay. Comments or questions regarding memorandum of understanding with the 3 lieutenants?
No.
No? Okay. Is there a motion to approve the memorandum of understanding with Lieutenants Ward, Pletnick, and Airy?
So moved.
Seconded?
All in favor?
Aye.
I just want to announce that Harsco Mylars are ready for signature, and I believe Ms. Gallagher has several items.
There are 2 resolutions before the board this evening. The first is a resolution that would be in opposition to a bill currently pending in the Pennsylvania State Legislature. The current version of the bill would essentially strip municipalities of their ability to zone what's known as distributed antenna systems. They're little boxes that go on top of existing utility poles that enhance wireless data service. Under the current state of the law, the township is permitted to zone these types of technology as well as regulate their position within the right-of-way. This legislation would strip the township of any ability to do anything of that nature. And so this is a resolution, should the board be interested, that would oppose that legislation. It's currently just pending in the House.
Okay. Yeah, we haven't had to really approve a new cell tower in quite a long time. And as the technology has changed, we're seeing companies that don't necessarily have to put in a big tower anymore or even co-locate on a big tower anymore, but what they can do instead is just start, they believe anyway, and they're pressuring people in Harrisburg to approve this, that they should just be able to put up smaller towers almost anywhere they want in the right-of-ways, which would mean areas right near people's houses, right in, essentially the space even between a sidewalk and a curb, and basically do anywhere they want, just to, as many times as they want, and really give us no power or authority to stop them from doing it. So we're, like probably almost every other community in Pennsylvania, against that. And so this is really exercising our right just to let the state government know that we think this is a bad idea. I know we did have a company that was coming in and looking to sort of build some of these in random spots. One was going to be near where the old Acme was. One was going to be right sort of across from, Mr. Rocco's backyard. And there was another one that was going to be somewhere else that was just like a very odd location right in the middle of a, yeah, near the Rite Aid. Yeah. So,
We haven't heard anything from that company in a while.
yeah, so that's what we're looking for here. That's what this was raised, and a lot of other communities are doing this. And so, if we're okay, is there any public comment? See no hands or a motion, and if there's no questions or comments, approve resolution 1732, correct?
Yes.
Voicing opposition to House Bill 1620.
So moved.
Second.
All in favor? Aye.
Aye.
Okay.
And there is another resolution in front of the board this evening that has to do with additional legislation that has been passed in the Commonwealth of Pennsylvania. It now expands the casino regulations to allow for what's known as Category 4 casinos, which are smaller mini casinos. These licenses would be issued to existing casino license holders, including Park, Sugar House, and Valley Forge. The way that the legislation works, an institution like Parks would be able to locate a Category 4 casino within 25 miles of its facility, but not within 25 miles of another owner's facility. So there's a small portion of Falls Township that would be available for the placement of a Category 4 casino by Parks. The legislation does give the township the ability to opt out, which is not an opportunity that townships are given quite often, so that this use would be prohibited in the township. So should the township wish to take that action, it would have to be before the end of the year, and that resolution would have to be delivered to the state by December 31st.
Okay, so all this happened, as you can imagine, very quickly. The expansion was just part of the budget that was a budget agreement that was done in Harrisburg to expand gambling as a way of hoping to close the shortfall in the budget. There's various expansions of different kinds of gambling at truck stops and other places, and I know the county's looking at banning those kinds of facilities, truck stop gambling in Bucks County, but this is more sort of a little satellite campus of a casino could open up in Falls Township, unless we pass something like this. Again, it is something that wanted to bring to the board's attention. Comments or questions from Ms. Gallagher regarding this, or thoughts about whether or not we would like to have a little mini Parks Casino somewhere in Falls Township?
No, I spoke to Ms. Gallagher about it, so it doesn't mean if there's an opportunity that we couldn't allow them to come here, even if we...
You could always rescind the resolution. You have to pass it by the end of the year, but you can rescind it at any time. It is likely that Parks Casino will get some of these licenses. As to where they're going to locate, that I don't know. There's not a whole lot within the county that they would be able to where they would be able to locate.
My mother can still get down to Ben Salem.
All right, so this would be Resolution 1733. Okay, prohibiting the location of a Category 4 licensed facility, mini casino, within Falls Township. Any public comment? See no hands. Is there a motion to approve Resolution 1733?
So second.
All in favor?
Aye.
Mr. Clark, you had something as well?
Yes, Mr. Chairman. I'd ask for a motion to permit my office to retain the services of Ronald Trankel, consistent with the proposal submitted on December 14th, 2017, to assist my office with a personnel matter on behalf of the township.
Okay. Comments or questions from board members?
No.
Okay. Any public comment? See no hands. Okay, is there a motion then to authorize the retention of, I was going to say the name wrong, sorry, Mr. Trankel, as outlined in his memorandum from December 14th?
So moved.
Second.
All in favor? Aye.
Aye.
Okay. All right.
That's all I have. Thank you.
Okay. All right. All right, we'll do up to board comment. Mr. Rocco?
Just happy holidays and looking forward to 2018. So,
Mr. Galloway?
Just a blessed Christmas and a happy holidays to everyone. Thank you.
Mr. Boraski?
Sure. I don't have a comment, so I kind of wrote my stuff down. I can read right off my computer, so I'm messed up here. But so last week, a friend of mine sent me a screenshot of a post on Facebook where two people over the course of a few days questioned the integrity and character of the township supervisors. It's hard to understand why someone would choose that platform or stage when we allow public comment before every meeting where you can question or discuss any agenda item or issue that you may have with either the township or a supervisor. On top of being able to speak at our meetings or question the supervisor directly at a meeting, we also have multiple boards and commissions in the township that are begging for volunteers, which would allow you to help make a difference and get involved. I decided while I was gathering my thoughts for board comment that I did not want to mention the two people from Facebook, and instead mention a resident in the township that has given many years of service as a volunteer. I want to take this opportunity to thank Mr. Rick Rittler, who has served the Planning Commission for 22 years. Last night, Mr. Harvey and I went to the Planning Commission to thank Mr. Rittler for his service to the township. Mr. Rittler is retiring and is not seeking reappointment to the Planning Commission. Rick, thank you for being a friend, and thank you for your service to the community.
Yeah, thank you. Well said. Yeah, it's, Mr. Boraski said, both of us really served. The first involvement I had with township government was on the Planning Commission back in 2002, 2003. And Mr. Rittler was on the board at that time. And Mr. Boraski came on the board after that and served for 6 years, 8 years?
Yeah, 6.
6 years. And again, with Mr. Rittler, you know, and really, it's hard to find, you know, we work with a lot of very, very nice people. We have a lot of great volunteers, a lot of great employees at this township building, and a lot of great people in the township that all do all kinds of volunteer work. But, you know, Rick Rittler's a real class act. He really is just a great guy, one of the friendliest people you're ever going to meet, and really knew his stuff. He worked in the field, and so he understands, you know, what it's like to come in here with a plan and have to go through all the zoning and the variances and you know, deal with people like Mr. Sullivan. And you know, he really did his best and to work with everybody. And certainly, it's tough to find a better role model. And so I know he certainly influenced Mr. Boraski, influenced me. So wish him all the best in his retirement. You know, he and his wife are looking to move down south and you know, enjoy retired life. So we're definitely jealous of him for that, and we'll definitely miss his valuable role he had here in the township. And the Planning Commission themselves decided they wanted to present him with a clock really engraved with his name, which was a great idea, and presented to him last night. And he was touched by that, and he was surprised, and definitely deserved the attention. And so, you know, we thank him. And again, you know, it is great, as Mr. Boraski said, to highlight the people who are doing positive stuff. You know, it's easy to be negative, but it's harder to sort of to be up here or be on any board and volunteer. So thank him for all his work. I want to thank the board for a great year. I thank our professionals, thank our staff here, Mr. Gray, and all the people that work here for all the things that they have done. And over the course of this year, we're looking forward to 2018. Our next meeting is our reorganization meeting, which is January 2nd, where we will have the swearing in of Mr. Galloway, Mr. Rocco, as well as our auditors, and the tax collector too, I think, is getting sworn in that night. Is she getting sworn in that night? Okay. And it really is just a very preliminary meeting, just establishing some basics, no real business going on, and presumably we'll still keep the third Tuesday sessions. This is tonight or tomorrow night is is the last night of Hanukkah, so I want to wish for our Jewish residents here in Falls Township and friends and neighbors blessed last few days of Hanukkah, and for everybody else a Merry Christmas, and best wishes for, as Mr. Mariani said, a very peaceful, you know, New Year in 2018. And at that, we've sort of reached the end of our meeting, and we'll entertain a motion to adjourn.
So moved.
Yeah. I'm sorry. Mr. Gray, was there?
This gentleman has a tax question about his tax parcel.
Oh, okay. Yeah, it's not really something, we'll talk to you in a minute, sir. So we'll yeah, absolutely.
Second.
All right, motion, okay. All in favor? Aye. Okay, thank you.